Hello and welcome to In Session. I'm Michael Ayala here with Judge Ashley Wilcott. Today we're going to take you through a couple of big cases going on right now. The Carmelo Anthony hearings are set to start tomorrow first. The motion to recuse and followed by that motion for a new trial. We're also going to take a look at the Tupac Shakur trial going on for Duane Keefie D. Davis and try to figure out exactly what's going on out there. But Judge, this has been an incredibly busy week in true crime. You've got the Fernandez Saldana case going on. You got Clancy going on. You got Tupac. You got the Carmelo hearings. I mean, there's just all kinds of stuff going on. And it's been kind of fun, but it's been exhausting, to be honest.
And not only that, that's true crime. Don't forget, we've got the mega lawsuit coming up. We've also got the AI lawsuit. You've been covering that. And yes. I just have to say one thing before, because you're right. It's very dense. It's a lot. It's a lot of thinking and researching. But on a lighter note, I just want to comment, Michael, you and I were just playing the music you have for your legal view, and I love it.
This is Legal View, where we look at the news from a legal point of view.
So I was waiting when you started ours for some good music, but we didn't do that.
I mean, that goes in post. You know, that's like, you ever hear that saying, I'll do it in post? I'm getting to the point now, Judge, where I can say I'll do it in post. You know what I mean? So I can do stuff.
Listen,
you know
I'm grateful. It's not my thing, but you're getting pretty good at it there, Michael Ayala.
Slowly but surely, man. And it's very satisfying.
Yes.
I must say, a new skill. I'm very excited. All right. So
let's
here we go. Court is in session. All right, Judge. Let's begin with the Carmelo Anthony case.
Yes.
The motion to recuse is tomorrow. We've been waiting a long time for this. The new appeals team that jumped on the case pro bono have filed that motion for a new trial. But before they get to that, they have to decide who's going to hear the motion for a new trial. Judge John Roach is the guy who sat during the trial. He would not recuse himself. In Texas, once you file a motion to recuse, first the judge has to decide, will he voluntarily step aside? This judge decided not to. So now another judge has been brought in, Judge Hall. I think it's Sid Hall. He's going to sit and hear the arguments by the parties as to why this judge should not be allowed to listen to the motion for a new trial, which will happen the very next day. The standard is very interesting. The standard is not if he's biased or you have issues with his rulings or, in this particular instance, the standard is Texas Rule 18B, which says extrajudicial comments by a judge. You take those into account. If a reasonable person, after listening to those statements, would feel that this judge could not be impartial when listening to that motion for a new trial, then that judge should be recused. So it's interesting. So what are your thoughts?
All right. So first of all, I wanted to comment on the fact that I like the process. I like that another judge has been assigned to hear the motion to recuse. All states have a statute specific to judicial recusals and the request by parties, right? And there are very specific statutory elements that you have to prove, as with many laws, to be able to get a judge recused. But to your point, if a judge says, I'm not going to recuse myself, because most judges are going to feel like I didn't do anything indicating I couldn't be impartial because I am impartial. So it's the next logical step that another judge is appointed who's going to hear this. And I want to get a little bit into the grounds for what the defense is arguing. First, I want you to weigh in on this piece. We know that Karmelo has a new defense team, and this defense team is led by Russell Wilson, and he's the one that we expect to be arguing that certainly filed this motion to recuse. What do you think of the new defense team, or the reason why he has a new defense team? Is it because you want fresh eyes when you come to appellate issues, et cetera?
Yeah, I think in part it's because they're two separate specialties. Trial lawyers generally don't handle appeals. It's a very different skill set. Trial lawyers are showmen. And then that's not to say they're not doing their research, they're not doing their homework, they're not working in that way. But appeals courts attorneys, very different. They're very into the minutia of the law. You really have to know your law. You really have to do your research. You spend a lot of time in libraries and you're writing and researching, and you have to enjoy that stuff. It's a very different skill set. And the really good ones also combine that with the ability to go into a courtroom and argue those oral arguments, right? And convince judges. So it's a very different skill set. So not surprised at all. Not surprised that they jumped on board. We both know this case has garnered tremendous public interest. There's been some issues. A lot of this has been divided along racial lines. Most of this team, not all, but most of this team is attorneys, African American heritage. There are a couple of attorneys as well who've joined. I think one is Arab. Another one is a white gentleman who's involved. So it's a sort of a mix. There's a woman involved as well. She's from the Crump firm. So I'm excited. I was excited when they got on board because I really lost trust in the judicial system with this trial. And it wasn't until they filed their motion, Judge, that I realized why I was feeling that way. There was that crazy deal. And I knew that what was going on in that courtroom wasn't the way this case should have been tried. And I was wondering why. Are they throwing the case? Is this guy really not trying to represent him? Turns out there was this deal, and that explained a lot. But I was glad that there were some fresh eyes and new folks involved.
And I think the fresh eyes not only pick apart the details in a different new way, but also takes the emotional away from it, because I'm emotional when I represent a client in court, in trial, because you build a relationship, you develop the relationship, you try the case, and your emotions can often feel bad after you lose a case, right? If you think you might win or you have an opportunity to prove reasonably out and then you fail, I think all of that can sometimes get in the way from being as objective as you need to be to determine every legal argument. And I think this motion to recuse is an interesting legal argument, but I also think it has pretty good merit. So I know today, in the interest of time, we're not talking about that motion for new trial. I want everyone to go to Substack because you are going to be posting about the motion for new trial with all those details. And part of that was when the defense says Roach limited public access to the trial because he did not allow, there was an overflow room for media, but he did not allow cameras in the courtroom. And that's part of that argument. But they segued from that into grounds for what I see they're alleging as a motion to recuse the judge. And part of that is this judge actually was interviewed. And I think, Michael, it was 2 days after the verdict, 2 days
It was less
after
than
the
48
verdict.
hours. It was about a day and a half, less than 48 hours after this comprehensive gag order was dropped because of the verdict. He's on TV.
He's on TV. Now, remember, it was a conviction for murder. He was sentenced to, I'm looking for the number of years, 35 years, sentenced to 35 years. And then the judge decides to go on TV and basically agreed that the jury got it right. And here's a quote. And the judge said he characterized...
No need to quote. I got it. I got the audio.
Michael with the graphic.
My primary goal in any case.
Let me find it. So, Judge, I got it right here. We can hear the actual words of the judge. Now, this was an interview done with WFAA. FAA did comprehensive coverage of the trial. And I just want to say, remember the standard, right? The standard is if the words said by a judge, these extrajudicial statements, would make a reasonable person think that he could not be impartial when hearing the motion for a new trial. Part of that motion for a new trial is that he didn't give enough public access, right? And that there were some issues with some of the decisions he made. So let's take a listen.
The media.
Did the jury get it right?
Yeah, they did. You know why? Because they were picked based upon the law. They listened to the facts that happened here in this very courtroom, and they got a verdict. And so that's the process. And whatever they say, they get it right.
So, Judge, I don't have a problem with what he said.
You do or don't?
I don't. I mean, that's legitimate. And I like the way he phrased it. The reason it's right is because they listened to the evidence, they were in the courtroom, and juries get it right. The problem is not the sentiment. The problem is the fact that he publicly said it.
Right.
And the rules in Texas, and you're a Texas girl, they discourage judges from speaking when their court still has jurisdiction over a case. And his court still had jurisdiction over that case because he knows that these post-conviction motions were coming.
Yeah, that's the problem. I agree with you. The way he said it was fine. If he was doing a talk not on a specific case, but rather on juries and jury selection or doing a CLE, and he made that statement, excellent. If he chose to make that statement about in general with criminal trials, this is what I find in my experience, great. I think the problem is he said that about a specific trial that's still fresh and the appellate process has not run out. I agree with Texas saying be very careful about making any statements about a trial during the appellate process because, okay, he said that. But here's the problem. What if they appeal on some grounds that they win? And that has to do with maybe they get new information, and this did not happen. I'm just saying theoretically, perhaps they learned something new, discover new evidence that a juror was biased or failed to disclose information on the questionnaire that it was a problem. Any of those reasons could cause a court of appeals to reverse and send it back down. And as a result of that, now you have a judge saying, but the jury got it right. I think you are correct. It's the context of saying it during the appellate process about this specific case that makes it problematic.
Judge, I got more problems with this.
Oh, are you going to play it?
Listen,
There's
I
more.
was so upset that this judge had this comprehensive gag order. Not only a gag order, Judge, but he took the extraordinary step of saying all motions or anything involved, subpoenas, anything would go through his office so that the public had no idea. The normal process is it goes into the public docket. The people can look in and see what's going on with the case. He shut the public out completely. Less than 48 hours after the trial, he decides that he's going to do an interview. And when asked why, he said, because I wanted to provide transparency. Ooh, that broiled my blood. Because what transparency are you giving us? If transparency was important, let us see the trial. Now we're going to get not transparency, we're going to get your point of view on the trial, which is a very different thing, which to me tells me about the mindset of this particular judge.
And I think it also goes specifically to the argument of the law that you made. You have to be unable to show that the judge could not be impartial in hearing this motion to recuse. And he can't be impartial because, in my opinion, he's doing exactly what you said. He wants his point of view to be heard. And if he's focused on his point of view and he thinks he's okay to say that, then he can't be impartial. I know that's circular reasoning, but that's where I land.
No, but it's absolutely right. Let's take a listen to something. This is the same interview. And I think this quote is even more damning in terms of, whether a reasonable person hearing this can think he can still be impartial.
I told you before, as long as I follow the law, I sleep well at night. And I'm telling you, I follow the law in that case. Did I know what the perception was going to be? Sure. I knew in the back of my mind what the perception was going to be. But I'm not here to satisfy perceptions. I'm not here to satisfy agendas. I'm not here to do any of those things. I'm here to follow the law. And I did it to a T.
We do. I'm a former judge. I thought I always did, Michael. But let me be the first to tell you, Court of Appeals don't always agree with you.
Right. And that's my point, Judge. There's nothing wrong with his sentiment. Yes, I get it. I am not suggesting in any way that he sat up there and made rulings that were, that weren't what he believed was the right rulings. Right? I have no issues with. I have no issue with a judge feeling that way. Like you said, you felt that way. Every judge feels that way. The problem is expressing it to the public, and specifically, the law says, right? The court publicly endorsed positions on issues it still had authority to decide. And the judge must recuse himself if impartiality can be reasonably questioned. The point is, the judicial branch wants to maintain the trust of the public.
Right.
So they have to maintain the appearance of impartiality. That's why the rule exists. And I don't understand. He seems like a nice man. Seems like he cares about the law. Why would he go and make these statements knowing that, number one, it's discouraged for judges to do that? And number two, he still had jurisdiction, and he knows these comments will be controversial. He even said it himself.
And I think the reality is no judge can risk or afford to make statements about a specific case during the ongoing appellate process because you still do have jurisdiction. I just think it's a risk. And I think you step in it, even if the comments you make are accurate, even if you mean well, it is a risk. And this is the very risk. Strategically, I think this is very smart lawyering by the defendant's team because in doing this, they're questioning the right things. The judge shouldn't have spoken all, in my opinion. Michael, I have to ask, did you also pull the part of the interview in which he chose to characterize the young man?
Yeah, I did.
Because that really flew all over me.
Okay, here we go.
And I'm proud of that.
What's your take on Carmelo Anthony?
I don't know. I really don't know.
You've had a lot of defendants in your courtroom.
I have had a lot of defendants in my courtroom, and I talked to Mr. Anthony a couple times because I'm legally required to go over some things with him. He seems like a nice young man who committed a crime, and he understands today, more than any day before today, the consequences of committing a crime like he did.
So, Michael, stop it right there. And that's the
that was it.
problem. If they make any allegation at all trying to reverse the decision or file any motions to help Carmelo Anthony as a defense team, the problem is he's now said he think he committed a crime. You cannot be impartial if you're standing behind the statement he committed a crime.
Yeah, I agree. And, I was shocked that he would, make that kind of assessment. I would have stopped right at, he seemed like a nice young man who possibly made a mistake or something. You know what I mean? Like, even that, doesn't really ring true to me. So it really was shocking to me. And again, those are legitimate feelings.
Yeah,
They're
of
fair.
course.
I think that's certainly how he feels. I have no issue with his feelings.
No.
Earlier, he even talked about, and it's mentioned in the motion that talks about, he sympathized. When they asked him, do you know the Metcalf family? He says, no, I wouldn't know them if they walked by right now or whatever. And he said, but I do sympathize with the situation they're in. I don't even have a problem with that. He's a human being. You guys
Yes.
put on the robes, you do your jobs, but you're human beings. You can sympathize, just have to follow the law. But again, it's not about what you feel, it's about what you've expressed and what effect what you express will have on the public.
And it feels bad. It feels bad for a judge to say there's a gag order. We're not letting the cameras come in and everything that's filed comes to me first. And then the first person that we get to hear from with any details about the trial is the actual judge. That just doesn't feel right.
Doesn't feel right at all. And the thing that struck me about this was that you are right. It does not feel right. And he was not personally aware enough to realize that. And it just tells me about the system there, the way these judges think and feel, because I go back to that decision to sort of close off the trial from the public. He did that on his own. Neither side made a motion to keep cameras out of the courtroom. There was never any arguments. There was never anything specific said. He just decided that we're not going to have cameras in this courtroom. We're not going to have the public at all involved in this in any way. No one can talk to anyone. Court personnel, witnesses, the judge, the lawyers, no one. And again, it's just the amount of control that they believe they have over the process without letting it play out the way it normally would. And that causes problems. And I think, Judge, in my estimation, this is one of those motions to recuse I think has some legs. What do you think?
I think it definitely has some merit. It's also now, do you not grant the motion, he stays on the case and you're perhaps borrowing more trouble, or do you, to make it clean hands, go ahead and grant that motion? Now you have to find that it meets the legal standard. But because a judge is deciding it, they can subjectively say these facts meet the legal standard. I think out of an abundance of caution that I would probably, based on what we know at this moment, grant that motion. But the other piece of this, to your point, is, judges are human. We make mistakes. We say things we shouldn't. I think I told you the first time I was on the bench, I was used to being a trial attorney, and these attorneys, where one of them was going on and on and on and on, getting all of this evidence in that they should not have been getting in. And I, all of a sudden from the bench, objection. And I was so embarrassed, and I had to correct the record, and I had to apologize to the attorneys. I had to call them up to the bench and say, are either of you wanting to object and to, make grounds for whatever argument you want to make based on my inappropriate action? And Michael, I was mortified. But the reality is we're human. So who knows how he feels after he said it? But I agree with you. I believe he stands by every decision he made and everything he said. And the fact that he granted an interview, I believe he stands by all of that and does not believe he has done anything wrong or inappropriate.
No. And we'll end it here. There's also another issue out there, Judge, and that is these deadlines are coming up hard and fast regarding ruling on these post-conviction motions. You get a 75-day window from the time that the verdict and the sentencing is reached to rule on post-conviction motions. Monday is the 76th day. Sunday will be the 75th. So they get till Monday. So if they decide to get a new judge has to come in, get up to speed on the entire record, and then listen tomorrow or the day after, which will be Thursday, to the motion for a new trial, and then rule by Monday in order for this thing to remain valid. If it doesn't, then it automatically is quashed and jurisdiction moves from the trial court to the appellate.
Yes, that's a lot. That's a lot. But any case of this high caliber, with all the attention on it, especially anybody who comes into this case, whether it's a new prosecutor, whether it's an associate counsel, whether it's a new judge, whoever it is, they're going to be buried and work with the timeframes under the law. That's just what it is now.
They are. And one would have thought that putting a new judge on it would have told that 75-day thing. It doesn't. It doesn't. That clock keeps running.
But I'm kind of glad it doesn't, because in the interest of the defendant, of the person who's appealing, of the person who's filing all these motions, I don't think it should toll it. I feel like justice needs to move forward and be swift if there are legit grounds that any of this needs to be changed.
And there's just a little context, because I don't think I explained it well in the beginning. The reason this happens is the law likes to give, or the system likes to give, the original trial court the opportunity to take a look back at some of their decisions and decide, maybe I made a mistake. Like you said, we're all human. Maybe you made a mistake before it goes into the appellate level. So that's why we do this. And these are not successful very often. Let's be fair. You have the same, normally, under most circumstances, the same judge who heard the trial will hear that motion for a new trial. It rarely gets granted. They all feel the same way. They all did the right thing, and they live with their conscience as far as that goes. But these are rarely go very well. And my understanding is, even as it gets to the appellate level, in Dallas or in Texas overall, I can't remember, it's about 4% of appeals are successful. So this is a very low percentage thing, because I've always said, once the system gets their grips in you, man, it is hard to get free.
Especially in Texas, the statistics are conservative. It's even harder, I would suggest, statistically.
Yeah, I need to do some comparisons on that. Sounds like an article, Judge. You might have to put one of those.
Right there. All right. We are going to, of course, continue to update viewers on that case. We are going to transition now to this case is one. Every time we talk about which cases to cover, I'm like, Tupac Shakur.
You love Tupac. That's interesting.
You know why? Because I remember him so vividly. In 1996, which is when he was killed, I was listening to his music. I was following what he was doing and where
Judge
he was.
Was a Tupac fan?
Yes.
I would have never picked that.
Yes.
Well, I guess everyone was. The charisma,
that's my point.
The talent, the kid was going to be a great actor.
Huge.
I mean, he had it all, right?
He had it all.
He was a little bit of a knucklehead, I got to say. But if he kept it together, he would have been incredible.
He had the talent to back it up. And it's the charisma, the energy. And because he was kind of a phenomenon, everybody talked about him, regardless of what you kind of music you might listen to all the time, right? He was music that people listened to, regardless of what genre they were real huge fans of. So I remember all this. Now, granted, I'd also just gotten out of law school. And, after 3 years of law school, you may recall this, Michael, the only way you can think is as a new lawyer. So you're analyzing everything. You're listening to everything. You're paying attention to all the crimes, to all the big cases, to all the things that are happening with corporate America and buyouts and blah, 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 because you're so engrossed and ingrained in thinking like a lawyer. And this is at the time I was a brand new lawyer and I couldn't help but pay attention to it. So let's talk about,
But
did
before
you
you
do,
go on,
were
I
you
just
this?
want to say for those who may not know, this was a devastating time in hip hop because within a very short period of time, and I believe this was 1996, I think it was
It was,
September of 1996, right? What's the date?
yes. Yeah,
September
that's
7th.
right.
Two icons of hip hop were murdered. There was this huge feud between West Coast rap and East Coast rap, and Biggie Smalls. He was killed. Tupac was killed, and it was just this devastating time for hip hop lovers, music lovers in general, because hip hop was so fantastic back then. Biggie, to me, remains probably the best rapper. So this just the
Wow.
context is during this time, it was really a devastating time. And that's why I think 30 years later, there's still interest in this case.
I agree with you. And not only that, like you mentioned, the West Coast, the East Coast, the feuding. And I think, at least I recall knowing about the violence, right, in that feuding. But I didn't think that it would get to the level of Biggie Small, Tupac Shakur, right? Like when it
Yeah,
got to
people
that
actually
level.
dying. Yeah.
Yeah. At this level and talent, and they're dying. So it was the first, I think, very publicized violence and murder of talented performers, artists, hip hop music stars that everyone knew of and knew about, and knew their music. So for me, it really stuck with me. Of course, this was in 1996, as you mentioned, Michael. And what happened was Tupac Shakur was in a black BMW. And actually, the first witness on the case, I digress just a little bit. The first witness called on the case was the patrol officer who pulled him over because they didn't have a license plate on their vehicle. And they said, well, we're shooting this video. This is what we're doing. And the officer said, okay, I'm going to give you a warning. You just need to put it back on. You need to have your plate on your vehicle, give you a warning. And they said, okay. And he said they seemed, not upset, very polite. Everything was fine with that. Well, then we know there was a white Cadillac. And we know Tupac Shakur was shot. And it was that same patrol officer who heard shots fired and went back and actually rode with Tupac Shakur to the hospital where he later died. So he was killed. Now, Duane Keefie Davis, what does he have to do with this? Well, part of what the prosecution alleges is there was a motive. This is why this guy was involved with it, because Tupac Shakur and members of his entourage had beaten up Davis's nephew, Orlando Anderson. And that had happened just earlier that evening at the MGM Grand Hotel. And so the prosecution
Which
says
I just want to interject for a second. The
yeah,
whole reason that happened was because of a gang feud. The Orlando Anderson, Keefie D were part of a rival gang, the Crips, and Tupac. And I don't know if Tupac was a Blood, but I know Suge Knight, who was the guy who ran
yes.
the label that Tupac was on, was a Blood. So that's what precipitated that issue. They were at a Mike Tyson fight in Las Vegas.
Yes. So all of this happens. Tupac Shakur gets shot. And Duane Davis, first of all, let's just talk about basic facts. Nobody is saying he's pulling the trigger. In fact, everyone is saying he did not pull the trigger. The prosecution said that in opening statement. He didn't pull the trigger.
Let's take a listen. Would you like to take a listen, Joe?
Yeah, Michael Ayala. Yes, please. Could we?
Let's
I think you have
take
it queued
a
up.
listen to the prosecution.
Duane Davis did not pull the trigger. But what he did do was plan the retaliation for the beating of his nephew. You will learn that Duane Davis got the gun. You will learn that he got into a white Cadillac. You will learn when the opportunity presented itself for retribution, Duane Davis made sure that the shooters were armed and ready to execute their revenge. And remarkably, you will learn that from Duane Davis himself.
I love that.
That is perfect. And I'll just tell you factually, I think I got every one single tiny of those facts correct because
You did.
I listened to these opening statements. I wanted to hear if there was anything different than what I expected. And the answer is no. The reason the prosecution can say, we're going to hear it in his own words, is prosecution has nothing to do with whether or not a defendant decides to take the stand. But rather in this case, there were three pieces of evidence that I want us to talk about, Michael, because I think all three are genius. First is that 2008 recording between police and the defendant, Duane Davis. It was made in secret. And what the prosecution says is that
Wait, it wasn't that secret. I have it right here, Judge. No,
well,
just joking.
no. I fully expected you did. I'm like, of course you did. Can
I
you
do
play
have
some of
something.
this,
I'll play in a
please?
second.
Right? But it describes Davis spotting Tupac Shakur hanging out of a black BMW on the Las Vegas Strip. And here is a quote again from apparently in this secret recording that they're going to bring into evidence that Tupac, he gave himself away. Otherwise, they would have got away. Now, in and of itself, is any of that language contained on the recording compelling evidence to you that Duane was involved in this?
So here's the problem. Let's listen to Duane Keefie D, because he did that proffer with the police. He had been picked up. I think it was, what'd you say, 2008? He
Yes.
had been picked up in some sort of drug thing. And so in order to deal with that drug issue, they were like, well, you better start talking. And he started running at the mouth, giving them this whole thing with Tupac. And then he's quiet for a while. Then he starts talking again. This is him. This is how he describes it.
So you and your crew, y'all on Flamingo and Koval, and y'all slowly pull up to Tupac and Suge in a black BMW. Tell me how that came about.
We just took the gutter lanes. Like we said, we pulled up to the stoplight, and they was making a right. It was about 17 cars. We just pulled up in the gutter lane and seen their ass. Yeah. And I first shot it, hit Big Boy in the head. I thought he was dead. Like, damn, he dead. And they didn't even give chase, make it so bad. Some brawls gave a chase. They got their little windshield shot out. It was over with after that.
So those are the types of things he's been saying around, right? And when you talk about whether it rings true, that's the difficult part of this. If you keep saying it. But the defense does have a defense, for lack of a better word. What they're basically saying is each time that he's telling this story, he tells it again in that proffer to the police. He tells it a number of times in a documentary film, on various podcasts. He writes a book where he reiterates how it all went down. And they say every time he said it, he did it for money. Or he did it for something, some kind of deal. With the cops, it was all about him getting himself out of trouble, keeping out of jail. When he started talking afterwards to the filmmakers, they paid him money to do that. The book author, he was the one that paid him money. He told a story, and the guy, Keefie, says, look, I didn't even write the book. He went off and wrote it and made stuff up. Then he just ran with it because people were willing to pay him to tell his story. So I don't think that that's so far-fetched. When you got a guy living, as we often do, Judge, we talk about people living on the fringes, you know, and you have this little golden calf that you can make money every time you open your mouth, it's very difficult not to open your mouth. So I think there's a viable argument there that he's telling the story for reasons other than the truth.
I think it's a great argument by the defense. I think that means this entire trial for each side comes down to one thing, Michael: credibility. This jury is going to have to decide his credibility, telling the truth or not. Did he make it all up? Now, the second piece of evidence that the prosecution gets to use that I think is going to be powerful for the jury is they compiled a highlight reel of Davis's podcast, television interviews, documentary interviews over the last decade, where, to your point, he is publicly bragging about his role as the shot caller in the killing. And they're using that. And I think, and again, that may not be evidence that's admitted, but the jury gets to see it. I think that's a compelling way to demonstrate this has been his version of what happened for years and years. But again, to your point, the defense says, so what? Every time he did it, cha-ching.
Yeah, he's getting money. And the judge, I mean, his defense attorney addressed, a reporter asked him, he said, you're basically calling your guy a liar, right? So how does that work out for you? Let's take a listen.
Client is a liar.
Yep, I am. Yes, that's true. I hope it goes down well.
So she asked him after that. The follow-up question was, and it was a long question, that's why I cut it out. She's like, well, how do you think that's going to go over in court, blah, blah, blah. And he says, I hope it goes over well. Because the question was, do you put Keefie D on the stand? If you're telling him that all these videos and all these things, even when he's talking to the authorities, he's lying. Now I put him on the stand because Keefie D likes to talk. Do I put him on the stand to talk some more and then tell this jury, well, now he's telling the truth? That's the difficult part. I don't think he needs to. I think his argument is strongest where he's just sort of poking holes at it by saying he's only talking because he wants to make money and he wants some street cred and all those things work for him. I don't think you put him on the stand.
Here's the thing, Michael, because I believe this is absolutely a trial about credibility. I think this always happens, but really in this case in particular, this defense team is going to be having to have someone watch every member of that jury and everything the prosecution is presenting. Because depending on how the jury responds, if they look like they're believing it all, they are going to have to put their client on the stand. It's his choice. But I really believe it depends on how the jury appears to be receiving all of this information and all of these interviews and the book. Don't forget, the judge ruled that the book can be used as evidence. The book that I'm referring to is one that he wrote in 2019, again, saying that he was the shot caller. The Compton Street Legend. Oh, I looked down and there it is. It's on the screen. Thank you, Michael Ayala. So that's another piece of evidence. There's so much evidence that he kept saying it, that if you look at the jury and think that they're buying the prosecution's story and thinking that he must have been involved or he wouldn't have said it, I think then he has to take the stand and he has to rely on his own ability to convince the jury.
I think this case, Judge, and you make excellent points. And as a result, I think this case was won or lost in jury selection. And I'll tell you why. There's 10 women and 6 men on the jury. Excuse me. There's 10 women, 6 men on the jury. The type of juror that you want is the type of juror that can understand someone like Duane Keefie D and why he might lie in dealing with police, in trying to get street cred, and what happens on the street. The second part of this is, and this is the second part of the defense, and actually the one I like the most, is that they go after the investigation and the lack of evidence. In his opening statement, the defense basically said they looked at this case in 2008, 2009, 2016, 2018, 2019. The feds got involved. Everybody was involved. Nobody brought charges because there wasn't enough evidence. The only thing that they have is Keefie D's words. So you got to remember that. The second thing he brought out was the corruption in the LA Police Department back then and how bad the investigation was. He talked about the original investigating officer was so worried about corruption and leaks in the department, he never gave anybody the evidence that he was collecting. So a lot of that initial evidence got lost. So they lost a lot of names of people that they interviewed. They never found the gun, never was able to trace and find the car. So the evidence is so meager, not only because it wasn't around, but also because of issues within the police department. So when you combine those two things, I think it makes for an interesting thing if you found the right juror who's willing to buy and understand. And I hate to say this, maybe like an OJ juror, right? They were ready to buy arguments about how bad the LAPD was because of that whole situation. Things are a little different now, so it might be a little harder.
Yeah, I agree with you. It does depend on the juror. Those are the jurors that you want, absolutely. But to your point, there was also no surveillance video showing the cars that they could look at to see who was in them. So really the evidence comes down to his words. It really does in this case. And The other thing I'll say about that, though, I think if the prosecution didn't have that police interview and they had to have testimony as to that instead, or if they didn't have the book, I think they'd really have a problem because it's been so many years since this happened, and 30 years. The witnesses they're going to call, they're all older. They may or may not recall it. They may or may not have the same memory of it. It would be a real challenge to try a 30-year-old case in any instance. And I think the only reason the prosecution's going forward is because of that book and that interview. That's my opinion.
Yeah, because there's no evidence, right? The
Yeah,
thing that really
I agree.
deteriorates is like the evidence, right? Your eyewitness. There's really none. The way they're building this case against him is they've taken his words. Now, in Nevada, you can't prosecute someone just on their own words.
Right.
You have to
there
have
has
evidence.
to be other evidence. Yeah.
And clearly there's other evidence in this case. The question is, how good is that other evidence? But the way they're going to put this together is Keefie was basically saying he wasn't in Vegas at the time. They're going to bring people in to say he was in Vegas and they saw him there. They're going to bring people in to say they saw him get into that white car. They're going to bring somebody in who's going to say he gave him the gun that was ultimately used, that Keefie ended up giving to Orlando to shoot Tupac. So you're going to get all those connections that are going to tie him to the crime, that are going to give credence to the story that he's actually telling. So if you can bring enough evidence in to corroborate his story, then the fact that they're saying he's lying doesn't really, it falls on deaf ears at that point, I think. So it's important how they're able to string together these older witnesses and these witnesses with these sort of memories that are 30 years long, and how they're able to string that together to support the idea that what he's saying is the truth.
Yep. Michael, there's one other little piece of evidence that stuck out to me that I want to get your thoughts on. So the same patrol officer I mentioned that had stopped the BMW with Shakur in it and then responded to shots fired was actually in the ambulance with Shakur. And he asked, according to that officer's testimony, when he asked Shakur repeatedly, who did this? You need to tell me who did this. He said Shakur was described as defiant and that he stated, quote unquote, no, we'll take care of it. Now, to me, that means Shakur absolutely knew who did it and absolutely was planning that there would be retaliation against that person. Does that assist the prosecution's case? Is that a piece of evidence you believe a jury might use against Duane Davis?
Yeah, what it tells me is that it was a gang thing. Right? Because gang culture suggests that you don't snitch on people. So him saying that suggests that he knew it was that rival gang. So I think it plays well into the prosecution's story that the motive was to be two rival gangs having a fight, and then they retaliated against them, and then now we're going to retaliate against you because that's the gang culture. So I think it plays well into the prosecution's story, and I think it was a good piece of testimony for them for sure. Because again, I think that's also a big part of the state's case. This idea, I think, we have often talked about cases without motive they can struggle, right? You can say somebody did something. What's the motive? We're looking at Lindsey Clancy, right? Be like, what's the motive? At the end of the day, prosecution doesn't really have a motive, and that's causing them to struggle a little bit. Here, the motive is very clear. And they're going to play that nasty, ugly, it's an ugly video of them beating up Orlando Anderson inside the MGM. A bunch of guys just kicking him. He's on the ground. It's just really ugly. And the idea that you would want to get some sort of retaliation for that, very understandable as far as I'm concerned.
Yeah, I agree with you. I think the motive is absolutely there. And I have to say, when you talk about motive, I want to talk about Patrick Clancy and Lindsey Clancy. I think why so many people online are talking about that case, and you again did another article piece about Patrick Clancy and why there aren't charges against him, or why legally perhaps there are no charges against him. The public is saying he had to have been involved. He did it. He should be held responsible if he didn't do it. Well, I think that's because there's no motive as to why she would have done it. And when there's no why or offered why, that's when people start to look at the rest of it and say, okay, there's no reason she would have done it. What else might have happened? That's what I think happens when there's no motive.
Yeah, I agree. I think it just leaves the door open for speculation and other things, and it makes it difficult to buy the idea that, because I think most of us, it's difficult to buy the idea that you just step out of the house and want to kill someone or whatever. So all these things just become in play. And I think you're absolutely right. This is the kind of conversation that people would have in a deliberating room. It's like, well, what was her motive? Why would she want to do that? Why would he want to do that? And if you can give them a legitimate reason to hang their hat on, then I think you've gone a long way towards getting your conviction.
Absolutely. Absolutely. All right. Stay
So
tuned. A lot on the
testimony,
case.
yeah, testimony's continuing in this case. We'll continue to follow it. Of course, we'll be watching closely to see if Keefie D ultimately decides to take the stand and testify in his own defense. I'm predicting no. I think the best course in this case for the defense is just trying to poke holes in the investigation, in the evidence that is presented, in the memories of the people who are testifying, and hold on to the fact that, Keefe's just this street kid who was, saw a pot of money and was doing whatever he could to get his hands.
We don't know.
All right, you want to switch gears now?
I do.
It's time for
a lot of
corner.
emotion. Family corner. Michael, so you know that my third and final child went to college, her first year at LSU this year. I'm very proud of all my kids.
Go Tigers.
Yeah, go Tigers. I think it's a great spot for her. I'm so thrilled for her. But, I have two boys.
Wait, hold on one second. That's in Louisiana. Did you go to school in Louisiana?
I went to Tulane in New Orleans, and LSU is in Baton Rouge. Yes, they are both in Louisiana,
right?
Yeah, and they're like an hour apart.
Those are very, very different cities, though, right? Baton Rouge.
They are, but Louisiana has its own culture, its own vibe, the
absolutely.
Cajun. And it's such a friendly place. People there are amazing and wonderful
Does
and
that
warm.
extend down to or up to, I don't know where the geography is, Baton Rouge? Meaning, I know because I've been to New Orleans. I've never been to Baton Rouge.
Same kind of
people. Does that whole
people.
Cajun thing still kind of flow down
Same
there as well?
kind of people.
Okay.
French Creole, absolutely. Just delightful, wonderful.
Good people.
If you
yeah,
need
fun
anything,
people.
let us know. Good people. So it's really a delight to know she's there for us to go visit. She's the youngest of three. And I've been through this recently because our oldest just graduated college, USC Film School. Our middle is at Emory going as a junior. So he's been there 2 years going for his third. And now Katie goes for her first year. Well, Michael, boys versus girls. Boys versus girls.
Yeah.
The boys pack up their clothes, for them, it was a real focus on the electronics, making sure they had all of the screens they wanted, the computer they wanted, all of those things was more of their focus. I had to twist one arm to even put a little rug where it was a concrete floor in the dorm. I'm like, you got to put a rug.
right. Their decorations are not really interested in all that.
Girls are not that. And so the deal with my daughter was A, buy cheap, and B, do it throughout the summer because I'm not paying one big bill. So she and her roommate designed their own room. Very good at it. Very adorable room.
They got together. Well, tell the whole story, right? She knows the girl.
The room, that's right. I wasn't going to say it, but yes, you're right. She does from middle school. So it's nice because they're not best friends. The girl moved away to Florida. So that's why they didn't live in the same city in high school. But the benefit is they know each other. They know each other's friends from middle school. They have common ground. So they did a phenomenal job. I wish I had it to show, but I don't because they're in it. The room they did, blues and greens and whites and golds and beautiful and lamps and a hutch. And the beds are up with storage underneath and desk.
I couldn't get my son to even put sheets on his bed.
Exactly.
I can barely
Michael,
get him to
you're
put
not
sheets on
kidding.
the bed.
No, you're not kidding. I literally, with my middle, said, "Let me make your bed." Nope, I got it. Can I please just make your bed? No. Finally, he said, "Fine, Mom, you're in my way. Make my bed. That's the one thing you can do. You can make my bed." Okay, thank you. And as I was doing it, I said, "Did you not want new sheets?" He's like, "Mom, you either make the bed quietly or you don't need to." Okay. Not the case. Not the case. And a cute story. So as we're in the room, because I had neck surgery, I couldn't lift things. So I was a little bit limited, but I took my best friend who helped us do this. And we have dads there and everybody else is there. And so we are in the room and my daughter was polite but short and said, "You're just kind of in the way. Can you please go find some waters? Because it's 109 degrees outside. You can cut it with a knife. So we're all sweaty. Yes, I'll go find the waters." Michael, we had just gotten downstairs. We put money in the vending machine. We pull the buttons. We get our waters. We sit down and the phone rings and it's my daughter. And I'm like, "Oh no." So I pick up the phone. You know what she says? "Everybody else is up here helping. Where are you?" I kid you not. I kid you
Yeah,
not.
she probably
So
forgot. She was so excited.
so excited. And all
Yeah.
these kids are nervous. They're
Yeah,
anxious.
nervous. Yeah.
A big state
Yeah.
school,
So you're
they had
upset.
it down. They were efficient, but it's a long process to get through all the lines for your 20 minutes of unloading, 20 minutes to
Yeah.
unload everything, and then
Yeah.
get it to your room and unpack. So it's a very long day. It's a lot. All during the summer, we were ordering different individual things from Amazon for the room. Here's where I'm going with this. That was Saturday morning at 11 was her time slot. Michael, by the time we left Sunday afternoon, parents were saying, oh, you're going to cry, you're going to bawl. And I said, I can't, I won't. I'm so exhausted emotionally, physically. It's a lot. All of us were exhausted. I said, who cries? At this point, you're so tired. All you can think about is getting rest. So we're walking to the truck. My husband's already in it. And I say out loud, oh, I'm not even going to cry. This is great. I feel really good about how we've set you up for success. She's gotten money on her own for school. Like, this is great. I feel really good. And I look over, she's bawling.
She's bawling.
She's bawling.
Wow. Okay.
Michael, I then start bawling. Duke, who you know, 6'7" Duke, climbs out of the car. He's
got
bawling.
Some tears coming. Yeah.
We were a hot mess. So college drop-off is not for the faint of heart. It's a lot.
I can remember, Judge, dropping my oldest off to college.
Yeah. And he's now graduated, to give a time frame.
Yes, he's graduated. He's doing well. But to this day, I remember the hug that he gave me when we were saying goodbye. He's not the biggest hugger. His hugs were always very loose, maybe one arm hug kind of thing, side to the head, that kind of thing. But this hug, Judge, this was a hug that, Dad, I'm a little scared. And he hugged me really hard, and he hugged me for a long time.
Oh,
I
I'm going to start crying.
And I held him.
Mm-mm.
And that first year proved to be a little difficult for him. And I think he knew it was going to be difficult, that whole transition into, like you said, big school. But man, I'll never forget that hug, So these kids, they feel it. We feel it, but they feel it too,
They feel it.
They feel
They
it.
feel, and you feel bad because they'll be fine. They'll get through it, but
And you can't do too much for them.
No.
You got to kind of let them fall a couple times.
That's what I would. They're going to fail at something. They're
Mm-hmm.
going to, and it's life, and you have to watch. But boy, is it hard leaving when they are holding on, and you're going to be okay, but you're going to have to go through some stuff to get there. That's
pain,
life.
Yeah. It's going to be some pain,
yeah. Happy she's there. Absolutely miss her, but it's the right, it's the right steps. This is what we raise our kids for, to move on.
You feel like you did the right thing, right school, everything, right? You feel good about the whole thing.
Feel good about it. Feel good about it.
Too.
And I'm going to say this, as we talk about college, it's not for every kid. And I love the families and children who, whatever their path is that they find, support it, because all these kids are different and they find different paths. But my point is, when they
in their own time, Judge.
That's
the thing I've learned.
Exactly what I was going to say.
It's like I did too much projecting with my oldest child, where I was worried about every little thing and what that might mean for the future. The kid is doing great. He's got his own thing. He's figured it all out. And for the second kid, I'm much more hands off because they figure it out. They're very individual. Can't force them into, square pegs into round holes. And they figure it out. As long as, you're good parents and you give them that foundation, they're going to figure it out,
They do. And I think in their time, that to me is the most important piece that can be really hard as a parent, but they all figure it out. So is she happy at the moment? Yes. Is she in the right place? Yes. But as we all do, we have to pivot if it changes. But as long as they're happy and focused on whatever it is they enjoy, I'm happy.
There's an old saying, as a parent, you're only as happy as your happiest child.
Oh my gosh, you are right. No, as
you can't be happy unless, wherever your happy kids are, you're right there. And if they're down here, you're down here. It's like you can't.
It's so true.
It's just one of those things.
I could be in a great mood, like especially after we'd be on air together, I'd have so much fun. I'd be in a great mood. And the second I got in the car, if I got a phone call, something was wrong, one was upset, my mood changed immediately to match theirs. Yeah, it's tough. Anyways, all is well that ends well.
It is.
My baby girl.
It was quite a process. I was there for a lot of it, trying to figure out where we were going to send your daughter to school.
Yes, it works out. Yes, it works out.
For all of us. All right, Judge, that's going to do it for us today. Another wonderful hour spent together.
Yes.
Truly appreciate you. Absolutely. It is, again, one of my favorite hours of the week.
Me too. Me too.
And folks, I want to thank you as well for being here with us. Again, this will be going up on YouTube as well as our individual Substack. So we'll put all that information up as well. We want to thank you for your continued support of us. And again, it's something that we truly enjoy bringing you.
Yes.
And Judge, court is adjourned.
Yay.